All rise. Court of Appeals Division 1 is now in session.
There we go.
All right.
Comfortable.
Thank you. Please be seated. We are here for oral argument in the matter of Femiano v. Maust. These proceedings are being video and audio recorded, and actually today for the first time being live streamed. So we ask counsel to please identify yourselves and your clients at the beginning of your argument. We also ask you to remember that because we're being live streamed, any comments that are picked up by the very sensitive microphones cannot be scrubbed. So be mindful of that. And that's for counsel and anyone who may be in the audience. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if desired. Also, we have read the briefs and have discussed the case in conference. Counsel, you may proceed.
Good morning. I'm here. My name is Timothy Rose. I'm here on behalf of the appellant Anna Marie Femiano. This court has received everyone's briefs in this case, and unfortunately, the under advisement rulings unclear on several of the issues. How should the courts address a potential preliminary injunction violation on property that may or may not be characterized as sole and separate at dissolution? When do you apply the elements of fraud and mistake at trial? And how much weight does that testimony carry when the court is going over the factors of whether or not a disclaimer deed is enforceable at trial? The trial court did provide a ruling that in this case, the marital residence was found to be husband, sole, and separate, and that the disclaimer deed was enforceable. And the trial court issued what I call the Dreyhus formula, for lack of a better analogy. And the court awarded the wife a fraction of what husband received from the proceeds of that residence. Wife's position at trial was that the house was community. That's why she testified of the statute of frauds. And in the holdings in whether it's Dreyhus or Bender or Bell Kilbourne, what is clear about those rulings is in order to request your community property interest in that asset at decree, you've got to go to trial. You have to plead fraud or mistake. There's no middle ground on
Counsel,
that issue.
Just for
Certainly.
dictionary definitions,
Sure.
will you agree there's a difference between community property and community interest?
Yes, I would. I would characterize
Because
that.
it seems to me like at times that's being improperly interposed. And so could you clear us up on that?
Certainly. In the early pleadings in this case, and I believe it was the proposed resolution statement, or I'm sorry, not the proposed, it was one of the early pleas at the temporary, maybe prior to the temporary orders hearing. We hadn't even completed discovery. Discovery hadn't even started at that point. We didn't even know the nature of the asset at the time. And I believe I've called it I said my client signed a disclaimer deed. We just simply didn't have any discovery early on. In this case, procedurally was a little unusual because when we had the order to appear hearing for the TO shortly after the case started, the case immediately got sent to a settlement conference.
Well, counsel, are you now arguing that it's the house should have been a separate asset, or that it should not have been a separate asset, that it's a community asset, or that there's a community lien?
It should have been deemed community property. That disclaimer deed.
Sorry, is that based on your fraud argument?
Based on not just based on the testimony around statute of frauds, but the evidence we provided that showed that wife and that the community did cash a check to the title company at the time they purchased the house, and if the community made all the mortgage payments, and if the community provided all these marital improvements.
But you end up with a lien on behalf of the community if the community's made contributions. If there's not fraud, and are you suggesting
Correct.
that the court's ruling was incorrect on fraud?
Well, the court really didn't address the fraud issue. The court just found that the house was husband, sole, and separate property, and therefore applied the Dreyhus formula. Our position at trial was
Well,
that,
just a moment, but
Sure.
the court did allow testimony regarding the fraud claim.
correct, it just wasn't in the ruling, so I don't know how the judge actually addressed that issue in the ruling itself. We testified to fraud and mistake.
Isn't that an implicit finding that the court did not believe there was fraud?
But he didn't specifically say that. And if you read the Jarejos case, you read Bender and Bell Kilborn, those cases strictly fell down, those decisions came down on whether or not the party alleged fraud or mistake at trial. And I would say that this ruling is inconsistent with how the trial courts typically deal with these issues. in
Isn't it
court.
entirely consistent if the court applies the Dreyhus formula? It's saying there was not fraud, so the disclaimer deed is valid. Therefore, we're going to move on to the value of the community lien.
I would agree if this court finds that the disclaimer deed is enforceable and therefore, and White did not rebut the presumption that the disclaimer deed was executed by fraud or mistake, then you will have to follow the Bender holding and apply the Jarejos formula. But White alleged fraud and mistake at trial. She provided clear evidence that not only did the community purchase the property, we provided the canceled check, and that the community made all the mortgage payments, but the community spent all these.
But how does that establish fraud?
Well, I think it goes to when wife executed the disclaimer deed, she testified to the elements of fraud. And by investing in husband's asset that's not hers, I think that furthers her testimony that she did not intend to give away all this interest. Because if you start using community funds on someone.
When you're talking about the interest, all we're talking about is a percentage of the appreciation and value of the asset, because the community has an interest under the Dreyhus formula.
Correct. And the problem with that calculation is it doesn't take into account the improvements. So if this court finds that the trial court satisfied the statute of frauds argument and therefore the statute of frauds did not apply, that'd be inconsistent with how in the Valento case, the trial court, wife claimed the disclaimer deed was non-enforceable and the court said it's being divided in half. In Division 2, we had the Quinn v. Sherman memorandum case I cited. Wife testified to the statute of frauds at trial. The court divided in half. The trial courts are routinely dividing these houses in half at the trial court level when you argue fraud and mistake at trial.
Okay, but let's clearly identify what was the fraud. The fraud isn't that community funds were used to pay closing costs or down payment. It's not that community funds were used to make mortgage payments. What is the fraud?
The fraud is at the time of the execution of the disclaimer deed, wife testified that it was her understanding, speaking to the closing, to the people that were doing the documentation, that this had no impact on her community property rights in Arizona.
Okay, and so she signs it.
And so she signed it.
Believing that she still is going to be part owner of the property.
Correct.
And now she testified to that, and husband said that's not true. He gave contrary testimony, correct?
Limited at best.
Well, he said he denied that he ever intended to go back on what the disclaimer deed, the effect of the disclaimer deed. He made clear that he never intended to include her as owner of the property, right?
That was his testimony.
Okay, and so the court, that's a question of fact, right?
Correct.
And it's within the court's purview to decide who the court believes, right?
Correct.
And we can't reverse based on the fact that we may believe wife more than we believe husband, even if that were the case, which I'm not saying it is, but even if that were the case, that's not a question of fact that we can review, correct?
That is correct. But the issue with this holding is the judge didn't give any indication on how much weight he actually gave the statute of fraud argument.
Well, but I think that's implicitly found when he proceeds to use the Dreyhus formula, because if he had believed there was fraud, then we would have done away with the disclaimer deed.
But the Dreyhus formula said absent fraud or mistake, you apply the formula. So I do believe if you apply the Dreyhus case, and the Bender case, the Bell Kilborn case, what's all those three cases have in common is they didn't argue fraud or mistake at trial. And so it would be
But just by arguing it, then the formula can't apply. Don't you make the argument. If the court doesn't buy it, then the court moves on to the Dreyhus formula.
And that's part of the problem with this, with having to argue fraud and mistake at trial. It means you're going to court. There's no middle ground here, which is why we prepared a couple of alternative formulas that try to take into account what happens if the court finds that the disclaimer deed is enforceable. If the court takes testimony, they say, I believe husband versus wife. The Valento case, that's what happened there. Wife signed the disclaimer, wife had husband execute the disclaimer deed. He said, I signed it. That thing's golden. The trial court still divided the house in half. This court reversed that decision and said, because husband signed the disclaimer deed, it was very that case was very, very fact specific as to how much they had dealt with real estate in the past. That is why the trial court, that's why this court reversed it back. They said that husband's testimony was more credible on that issue. But the larger issue, especially, and you can see in the Valento case, is the spouse who holds title essentially gets to dictate from the get-go of the litigation what characterization this disclaimer deed is going to have on that property. If the house has equity in it, as it did in this case, and as it does in a lot of cases, the party's going to say, hey, the disclaimer deed is enforceable. You get your Dreyos formula. Go to court.
Counsel, we're acting like a disclaimer deed is somehow a toss-up. Once you sign the disclaimer deed, any number of different things can happen. A disclaimer deed does one thing. It disclaims interest in property. So I'm kind of confused about the fact that your client was misled as to the meaning of a disclaimer deed. Or, I mean, it seems to me like that's something that ought to be readily available. And all this confusion now about how are we going to interpret this? How about if we interpret it the way we've always interpreted disclaimer deeds? It does one thing, doesn't it?
And the purpose of the disclaimer deed is to identify who purchased the funds to purchase the house. The disclaimer deed says that. And how the down payment was
disclaims
used.
an interest in the property.
True, but as soon as you start adding in improvements, as soon as you start adding in outside factors that nobody could possibly know at the time that disclaimer deed is enforceable, you can't apply the Dreyos formula in that manner.
Sure you can. If you've made capital improvements, that factors in. The court here, my understanding was that simply, you can't just say if I've done routine maintenance on a house that increases the value of the house. But I think the Dreyos formula contemplates capital improvements and contributions by the community.
The Dreyos formula anticipates repairs and mortgage payments, and that the increase in value is due to the general rise of markets. There's no factors in there that the parties contributed to other than make the normal mortgage payments, pay the property tax, and the house goes up in value. I would suggest that the Bell-Kilbourne case probably gives some guidance to this court on what to do when there's improvements. The Bell-Kilbourne case, after it was denied, is essentially our ruling here. You have a house that was titled in one spouse's name. The spouse didn't allege statute of frauds in that case. We did, but that's currently here. And the trial court found that because the house was purchased with sold and separate funds, that the house was that spouse's sold and separate property because husband didn't even allege fraud or mistake at trial. And the court ruled accordingly. So at this point, you have our case. This court could have applied the Dreyos formula at that moment, but they didn't, because this court recognized there were also improvements made to the house.
Okay,
And
How would they
just a moment.
Go ahead.
And you mentioned this in your brief. You say that in Bell-Kilbourne, the court did not apply the Dreyos formula, but it could have. The Court of Appeals, correct?
It was remanded back to the trial court to determine an equitable division because it was recognized that husband had made mortgage payments and improved the residence.
But isn't it true that in Bell-Kilbourne, the Court of Appeals said that the Superior Court on remand gets to choose what equitable remedy it's going to impose so that husbands or the communities and contributions can be recognized, and listed the Dreyos formula as one of the options?
Correct. And the problem with that is we don't know what happened at that point. If it had gone back on
Bell-Kilbourne stands for the proposition that the Dreyos formula applies in that context. Does it not?
But we can't conclude that also includes the improvements, because this court didn't apply Dreyos and say follow Dreyos. This court sent it back for an equitable division because of the improvements on the residence.
Are you talking about improvements in this case, that there were some capital improvements, or just that?
Absolutely. We provided $33,000 and some change with canceled checks showing all the different improvements. Again, the parties only owned this house for 20 months. And that's kind of the issue with the Dreyhus formula. The Dreyhus formula assumes when they can determine the equity in a house, they assume the house was bought the day prior to marriage. So when you create that, so when you plug in the factor for the equity division, because everybody already knows you get half the proceeds. You even get that if the house is upside down, as in the Valento case. But the factor drastically changes if the parties plug in a 20-month length of time they own the house, which is what occurred in this case, versus 120 months, which would have been a 10-year marriage in this case. So as soon as you plug in that factor of how long they actually own the property, but you drastically inflate the increased appreciation because of those improvements, the Dreyhus formula then isn't applicable.
But isn't that also, the question of improvements, isn't that also a question of fact?
And
Because you can move into a house today and put a $10,000 AC unit that isn't going to improve the value of the house. It just makes it so that you don't bake in the house when you're living in it. I mean, but it doesn't improve the value of it because it's supposed to have a working AC.
Right, and I would probably say that's probably more of a repair than improving the backyard, which was one of the things they did in this case.
Well, but again, isn't it a question of fact for the court to decide? Let's say that the court, you know, the house has a backyard with lavish landscape, and a couple moves in and they take out all those trees and plant a different type of tree. I mean, it's not a repair. The trees were fine, but they figured these are nicer looking trees. The court can decide, you know, that really it doesn't improve. It may improve your experience in the house, but it doesn't improve the value of the house. I mean, my point is it a factual question for the court to decide whether monies can put in by the community into this home actually improve the value of it?
Absolutely, I think that's a factor that the court needs to look at.
And the court can decide that it did improve the value or that it didn't.
Absolutely, and in this case, the court said the house was worth $284.99, and they ran the Dreyhus formula. And we create, and I went back and forth over how to address improvements because it's common knowledge that you don't ever get 100% value back on your return. And so I went back and forth on whether or not do I divide the improvements in half the same way I did the principal mortgage payments. And the reason why I ultimately came to that decision was this. The spouse that holds title is going to get to, assuming the disclaimer deed is enforceable and the parties don't go to court arguing fraud at trial and the judge doesn't find the house community. So we're assuming that that the disclaimer deed is enforceable. The spouse that holds title of the house is going to get the benefit of that improvement long after the divorce is done. The spouse that doesn't hold title is going to have to go out into the open market and try to buy an asset that's comparable, and they're going to spend a lot more than the half they're receiving.
Are you saying there's a specific item that was argued to the trial court that the trial court should have found increased the value of the house as opposed to was just something that was an expenditure for the enjoyment of the owners?
Wife testified as to what those expenses were and provided a spreadsheet and canceled checks. In addition to the canceled check showing that the
But
community
which
paid
of
the
those
business.
are you suggesting the court made a mistake on by not saying the value of the house increased?
The entire $33,000 and some change we identified at trial were we believed were investments. It was probably a conservative number. I didn't go through and itemize every single checking statement. We took out the ones that seemed like they were the most obvious. And that was what was a little bit frustrating with the ruling in this case, because even if you just made wife whole on that, because if you're investing property and ask community funds to an asset that doesn't belong to one spouse, and that one spouse is never going to get the return on their investment, that's marital waste. So assuming the funds were sitting in a bank account at this point, and wife had gotten half her money back on the down payment and half her money back on the improvement sheet identified, and you ran the Dreyhus formula, it would essentially still been half. So the ruling just simply didn't make any sense on that issue. I mean, the Dreyhus formula assumes the house is bought prior to marriage. The Dreyhus formula assumes that one party used sole and separate funds to purchase that house before marriage.
Counsel, you're not saying that a married person should never be permitted to purchase property and own it separately.
No, I absolutely think there's times the Dreyhus formula post nuptials is absolutely enforceable. I'll give you an example. You get inheritance and use that $50,000 inheritance at your sole and separate property. You buy a house for you and your spouse. Spouse signs a disclaimer deed because she didn't put the down payment down. That's fair. That's equitable. She doesn't have any skin in the game other than the mortgage payments and the general rise of inflation. But as soon as you start mixing in investment improvements, then that spouse is almost an investor at that point.
But you're ignoring that the spouse who's named the properties and assuming they're taking out a mortgage, and that spouse now has the obligation of the mortgage. And if the marriage goes south, it's that spouse alone who's responsible on the mortgage. Doesn't that weigh in favor of, in terms of equities, of giving more of the increase in value, that person is the only one who's responsible for that mortgage?
Yes, but I guess it will depend on two things. One, are you going to take a position that the disclaimer deed is unenforceable at trial?
I'm sorry, what is not enforceable?
If you take a position at trial that the disclaimer deed isn't enforceable, then potentially the house will be communicated, and and depending on how it's divided at trial, could theoretically give into the other spouse, I guess. You would have to retitle it, and that's no different than how we retitle cases right now. The spouse does hold more of the risk, but the spouse is also receiving a larger benefit from all those alternative Dreyfus formulas than the spouse that doesn't hold title. And which is also why I suggested, and I've been on the receiving end of, I've argued Dreyfus.
Counsel?
Yes.
You're out of time.
Thank you.
Thank you.
May it please the court, Emi Koyama, counsel on behalf of Abelie Douglas Maust. I'm happy to answer any questions that the panel
Can
may
I ask you a
have.
question really quick?
Absolutely.
I'm hearing an inclination, a tendency, whatever you want to call it, to lean toward the notion that the court just has this open-ended right to treat property documents however they determine appropriate to treat the property documents. I was raised in a culture in this profession where if you sold a property and you gave them a deed, that deed was going to be honored to prove ownership. Does that make sense to you?
Absolutely.
The idea of going to the court and saying, well, Judge, we think maybe it's less than ownership. We may think maybe it's just a long loan. That's not the way it works. How is it that we have a disclaimer deed that was put in place for a very specific reason, right? And yet the court was just going to decide how it was. There a point at which the court said, gee, I'm not sure how I want to decide to treat this disclaimer of any ownership in this property? I'm lost on how that became a real easy upfront issue before then we decide what we're going to do under Dreyfus.
Absolutely. Your Honor, I think that it is a very clear issue. And I think as the panel suggested earlier, it's implicit that Judge Driggs at the trial court level found the disclaimer deed to be valid. Husband's position is that the deed is valid.
Now the issue that was raised contrary to that was fraud.
Correct.
It had been fraudulently, obtained. And then today we're hearing that the fraud was in that opposing counsel's client didn't know what it meant. That's the way I took it. That's the way I understood it, was that she didn't realize the ramifications of that.
That's what I understood her testimony to be. And I think a little bit of background might help the panel understand husband's point of view and perhaps give light into Judge Driggs's consideration of the issue. Wife, throughout litigation, maintained that the home was sole and separate property. She did so implicitly because she constantly and repeatedly pleaded only an interest in a community lien on the property. You cannot have a community lien on a true community asset. So necessarily then the home was husband's sole and separate property. Even after the home sold and we attended a resolution management conference, wife in her pleading, her proposed resolution statement, again referred to the property as sole and separate by again claiming only an interest in a community lien on that property. She did not plead fraud at all. Literally the day before trial, she submitted her pretrial statement late and cited only the elements of civil fraud. She gave no indication whatsoever of what her testimony might be to support the actual fraudulent allegations against my client. We made an objection at the very beginning of the trial that morning, and I think Judge Driggs agreed in spirit that he was not sure where the argument of fraud came from, because the pretrial statement didn't lay it out as required by statute. That, if you plead fraud, you can't just list the elements of fraud. You must also plead allegations with particularity. That was absent in the pretrial statement. And the only testimony then given at the time of trial was when wife claimed that she did not know by signing the disclaimer deed that she was actually giving away all interest in the home. So it was the first time in all of litigation, almost 17 months of it, where wife now characterized the property as community property, because she was arguing by a shoehorn argument that now the deed was invalid because of fraud.
Could I change directions a little bit and just
Yes.
ask you to address the improvements
Yes.
to the property?
Yes. Well, wife did testify. She produced a self-prepared chart showing receipts and canceled checks for things like extermination bills, random ATM withdrawals, purchases from online retailers. And she testified that all of those purchases on that chart somehow improved the value. But pursuant to Valento, the court did not consider any of those expenses to have actually improved the value, because Valento, which by the way also applied the value at dissolution formula, or the Dreyhus formula we've been using here in context, needs there to be proof that those improvements actually enhanced the market value of the property. There was no evidence as to that, and I
A
believe
factual determination.
correct, Your
So you
Honor.
would agree if there were improvements, capital expenditures that improved the value of the property, that would be accounted for as part of the Dreyhus formula? And
Absolutely.
you're just saying none of those expenditures satisfied that?
Correct. And counsel suggests that the court made a mistake by at least not including in his ruling findings specifically as to fraud or how the improvements didn't improve value. It's not Judge Driggs's responsibility to determine what value there was. There was no expert testimony. There was no second appraisal to show specifically how those improvements improved the market value of the property. But also, counsel did not ask for specific finding of facts to be made. And per Berryhill, this court has to assume that Judge Driggs made all the necessary findings to support his ruling.
If I could change directions one more
Of
time.
course.
The Dreyhus decision provides a formula for determining the separate interest in the property, and includes the value of the down payment, puts that over as the numerator over the purchase price. And here the separate property was zero.
Mhm.
So how do we, this does have an element of unfairness. If you're applying the Dreyhus formula, and we're just going to look at the separate property interest in it, it
Sure.
starts off as zero. I understand your answer will probably have to do with the mortgage, but do we just ignore that part of Dreyhus that says the separate property interest is determined looking at the value of the separate assets that were used to purchase it, and any separate mortgage payments that were made using separate funds? And here, none of that apparently happened. It was all community funds.
Correct. It was all community funds. And I think counsel gets to that himself in his brief and his argument that the date of the acquisition being during the marriage somehow makes Dreyhus then inapplicable.
Well, I'm not concerned about the date of acquisition,
Sure.
but the fact that there's zero separate funds that are ever put into it.
Mhm. I think that the court has to look at the laundry list of prior decisions that support that regardless of the source or the nature of the funds used to pay for that separate asset, do not invalidate the fact that there's a valid disclaimer date that must control in the absence of provable fraud or mistake.
So then if an unfair result will be yield, can't the court use a different formula other than Dreyhus?
Well, counsel suggested that there is actually case law out there to support discretion to use an alternative formula. He cited to the Kelsey decision, which I believe is inapplicable here. It's discussing the proper valuation for a business entity as opposed to a piece of real property. And in that case, sure, the court has discretion to decide which valuation to apply to a business entity, because there are several different factors that might go into it. Just off the top of my head, whether a business is a retail business or a service-based business. But when it comes to real property, I think that, again, the court has to rely on that laundry list of prior decisions that say that the value at dissolution property, not necessarily just the formula resulting from Dreyhus, applies.
Well, value at dissolution is a formula well articulated in Dreyhus is not the only way to determine an equitable distribution, correct?
Correct. Wife did not propose any alternative formula at trial. She raised several alternative formulae in the opening brief, which I think it would be inappropriate for the court to consider at this stage, having been raised for the first time on appeal.
There are other cases where there's zero separate funds. What's your best case that says Dreyhus should apply in every additional, the appreciation in value goes entirely to the person whose name is on the deed?
I think the Valento case is probably most on point, because then it also discusses the value at dissolution formula and accounts for improvements that provably enhance the market value that should be added to the principal within that formula.
And Valento was zero, I've forgotten, was zero separate property?
I believe the home was purchased using community funds, and there was a disclaimer deed in that case. I could be wrong. I don't have the full case in front of me. But I think Your Honor got to maybe the counter argument to that earlier when you suggested that the spouse whose name is on the title and whose name is on the financing being solely responsible then for the obligation on that property. I think there is sort of a level of fairness then in the trade-off. You know, in this particular case, actually, the parties owned a second, or I guess it was technically their first home earlier in the marriage. Wife also signed a disclaimer deed for that, and that was part of husband's testimony to refute wife's allegations against him about whether or not she knew what she was signing, having been the second disclaimer deed she had signed in the marriage. They lost that property to foreclosure, and that affected husband's credit solely and separately, not wife's.
So I guess the other side of the coin wife proposes would be that if the market's upside down, then husband could argue potentially that he never intended to excuse her from the responsibilities of the loan. We never really intended for her to be off. She was going to be part owner. Hey, we're married. You need to go after her too, right? But that no one has proposed and probably hopefully never will.
No, that's not the case
But
here.
certainly going after is different than saying we're going to divide assets when we get divorced. And when we say husband has taken responsibility for the loan, certainly going forward after the dissolution, he's the only one on the hook. But the unfairness comes into play with the appreciation that's accrued while the entire community is paying every penny of the loan, even though he's the only one on the hook for it. The community has shouldered that burden for at least the period of the marriage. And so the appreciation while the community has assumed responsibility for paying the mortgage is where the element of unfairness comes in my mind.
I understand.
And your response to that is just?
If I'm being honest, I would agree with you in the spirit of the argument, but I think that that's contrary to what Arizona law holds, that the value of dissolution formula still applies. We have a valid disclaimer deed that was not invalidated because of fraud or mistake. Fairness aside, wife signed the disclaimer deed. It must be upheld.
Well, do we really have to set fairness aside? I mean, or does Arizona law stand for the proposition that there's value in someone who comes to the marriage with better credit, more financial stability, and ready to shoulder a financial burden that the other person, for whatever reason, can't, and ready to take on the risk that sometimes comes with that?
Yes.
But isn't it also a case that it seems like we've seen these in multiple cases? Sometimes it's just a simple matter of the parties get a better interest rate by having only one person on it. And so someone has signed over. There's a disclaimer deed, and if you're simply talking equity and fairness, they've gotten the benefit of a lower mortgage rate was really the only reason for doing it. And it does seem rather unfair to then extrapolate and say any increase in value goes only to the person whose name is on the deed.
I can understand and appreciate that, but I believe it's the Bell-Kilbourne case that discusses the reason for entering into the disclaimer deed. And in that case, I believe it specifically was because of advantageous financing that one spouse would have as opposed to both of them on the financing.
And in fact, in this case, the disclaimer deed is the devil we know, isn't it? I mean, there's a downside. We know that, but there's a benefit to be gained as well.
Yes, absolutely.
And so what we're going to do is superimpose ourselves over the top of the well-reasoned decisions or the considered opinions or the best advice provided, because after the fact, something was imposed, superimposed, whatever you want to say, that they didn't anticipate or they didn't think would actually ever happen. Does that make sense to you?
Yes, it does.
But like I said, the disclaimer deed is the devil we know. We know the effect. Do we not?
I agree with you. If I may, just address a few other issues, not necessarily raised in oral argument this morning, but in our brief, I did just want to sort of preserve for the record that the preliminary injunction, I think this was mentioned at the beginning of oral argument, preliminary injunction does not apply in this case. Wife, I think for the first time and only at trial, because even post-trial, post-decree in a motion for new trial, again referred to a community lien on separate property. Preliminary injunction doesn't apply, but also in her pretrial statement, she never raised that there was any violation of the injunction. She never filed any kind of petition for contempt to ask the court to make any findings as to whether or not the preliminary injunction was violated somehow, even if it were to apply. And as an alternative argument, even if the preliminary injunction did apply, I think that husband complied with the spirit of the injunction, which is to allow the court to have community property within its reach to then divide during litigation. And husband testified that he kept sale proceeds from that marital residence in our trust account. So it was always untouched and preserved, ready to be divided later. And separately, although the spousal maintenance issue was not raised today, I think that the court had the discretion to determine the appropriate amount and duration of an award. Wife actually testified that her income was $1,200. She testified that her expenses were $1,700. And the court might notice then that its award of $500 is exactly the difference. The court also found, based on his observation of her as a witness and her credibility, that she had the ability to earn a lot more than $1,200. And so I think that those were all factors, even though they may not have been expressly stated in his ruling, that went to support his decision for $500 a month for 12 months. There's no indication in the ruling that the court actually used the fact that husband had to pay for a vehicle to then reduce the amount of spousal maintenance owed to wife. The court necessarily must account for one spouse's, the spouse that who would be responsible for paying spousal maintenance, what his reasonable expenses are, and that would arguably include a car payment. As to husband's income, he provided an affidavit of financial information with tax returns and his recent pay stub to confirm that his income was only $29 at the time. And earlier at temporary orders, he did testify and present evidence that he was no longer full-time employed. He was just taking contract work with the electricians union, and to this day actually remains unemployed in the traditional sense. Wife argued in her brief that she's owed attorney's fees simply because of the disparity of income between the parties. But I think the ruling speaks for itself when it says that notwithstanding the disparity of income, wife behaved unreasonably by taking positions inconsistent with Arizona law, and she continues to maintain those positions, at least in my opinion, today. And I suppose more as a procedural argument, in her opening brief, wife argued that the motion for new trial should have been granted and asked this court then to consider that on appeal today. But this court also issued an order requiring wife to amend her notice of pleading if wife wanted to include the motion for a new trial and the subsequent award of attorney's fees in this appeal, and wife failed to do so. So it is our position that the motion for a new trial is not before this court, as it lacks jurisdiction to do so per the original unamended notice of appeal. That's all I have.
Thank you, counsel.
Thank you.
Counsel, we thank you both for your arguments. This matter is now under advisement, and we will issue a written ruling in due course. Thank you. We'll take a brief recess to prepare the courtroom.